I guess we still got a couple minutes.
Yeah, you're good.
That is just a copy, John. Scott's voice statement.
Oh, okay.
If he can't finish it due to health problems.
Gotcha. All right, I guess it's time. All right, call this meeting to order.
John Bushman,
Present.
Jeffrey Campbell,
Present.
Corey Rodriguez, Dan Sharkey,
Present.
Jeffrey Smith.
Present.
All right, I guess the first item is the approval of the agenda.
Do we second it?
We need a motion.
Motion.
Motion approved.
Yep.
I'll second.
Second. All right. All in favor?
Aye.
Aye. All right. And approval of the meeting minutes from November 30th.
Motion approved.
Second.
All those in favor?
Aye.
Aye. All right. All right, I guess next on the agenda is the public hearing regarding 54 Showers Lane, request for a special exception.
So I'm going to read a staff report from the Planning Commission's recommendation. Again, this is a public hearing for a request for special exception. The project is 54 Showers Lane. The file is 2112-438, and the owner is Gamachi and Associates Real Estate, LLC. It's located in the Arden Tax District, Tax Map 2L and Parcel 47. It's located at the intersection of Showers Lane and Tuscarora Pike. The applicant is requesting a special exception in accordance with Section 610 of the Tuscarora Community Zoning Ordinance to use the existing structure as a real estate office. The site is located within the growth area as shown in the comprehensive plan and compliant with the subdivision ordinance. Therefore, staff recommends approval of the special exception to permit the use of the existing structure as a real estate office.
Okay. I guess next would be the applicant presents their portion of their case.
Hi, my name is Danya Gamache. I'm the owner of 54 Showers Lane. Also, my husband, Rick Gamache, who is right over here. So I'm a resident of Berkeley County. This would be our second residence that we have. Also, a local real estate agent. I'm a president of the Eastern Panhandle Board of Realtors. I'm a voice for property rights for buyers and sellers throughout the entire state. Also serve as a state director on the West Virginia Association of Realtors. Never thought that I would have to represent myself as a voice for property rights. When I did purchase this property, the deed and the zoning ordinance states that you are allowed to have a real estate office, that you're allowed to have an accounting office, many other types of businesses, which are actually already located and two next door to me, and within 11 that I can see within a sight line of a half of a mile of my location. So I did not think that I would have any type of an issue with this. We are a very small firm. The reason why we decided to open our own, I actually work for a larger franchise. I'm a half a mile down the road on Delmar Orchard, right across the street. Been there for 5 years. When COVID has come, we have 4 children, 2 smaller at home, and being able to, when we have virtual learning, them to be able to come to our office, bring our dogs, make ourselves at home, cook a meal if we want while we're sitting there doing our clerical work, but being able to separate our home from our office was absolutely ideal for us to get our own and have some independence. We absolutely love the location. I represent a builder, have a new construction community that's up off of exit 16, sometimes off of exit 12, and some of our other offices are all the way in Charlestown when I work for ERA, let alone Martinsburg. So the ideal location here, as well as I'm right across the street from my bank. I can get anywhere easily versus where we live, which is Back Creek Valley. So it takes us a good 35 minutes. So when we have a second home, which we wanted to turn into a real estate office to be able to be ADA compliant, which is very important to me. My brother was born handicapped. I represent clients of all types of handicaps. I have to follow all fair housing guidelines, and I also have to make sure that if I open up a business, that it does need to be ADA compliant, which would be the reason why we would like a special exception versus just using it as a home-based business. There's a difference between the two. So I did do some traffic data. So when I pulled the Bureau for Transportation Statistics data published November 23rd, 2018, states that a standard 4-person household with 4 licensed drivers in a 3-bedroom home take 4 to 5 trips on a daily basis. So that would actually be up to 10 times of one licensed person leaving that home a day. So that could actually be 40 trips for one household. We are a 3 licensed real estate firm. It's myself, my husband, and we have another agent ourselves. So 3 cars who may use an office on a daily basis is actually no different than what a licensed household home would be. That's a 3-bedroom home. So any family that would move into that, let alone the renters that were there for 10 years that had multiple vehicles at that home, we are no more of an impact. If anything, we're actually less of an impact on traffic flow or any type of impact on the community. I just would like the blessing on what the zoning ordinance states that it allows and what the deed also allowed when we bought this home and we spent our savings on this property to do so. Thank you.
Are you planning to live there?
No, sir. No, we
It's a
don't want.
second location, but you
Yes,
can live there.
we do not want it to be a home-based business. Now, it also states in your zoning ordinance that it cannot be a commercial space and someone live there. And I do know for a fact that there is another business in the area that does have a livable apartment above that Tuscarora zoning has also approved. I'm not asking for any of that, just a straight business. My home is a very large rancher out in the middle of nowhere. This would be a hub for me to stop and use a computer, print, make a lunch, take my dog's potty instead of having to drive 45 minutes home. My kids can do their schooling there if it's virtual.
Thank you.
Any other questions?
Would you ever anticipate even having one customer there?
Well, of course. So I did actually pull that data as well. I'm a top producing agent in our area. I did over $12 million in volume last year. So that was actually representing 36 clients. Now, in those 36 clients, only 3 came to my office last year.
Okay.
3 out of those.
Would there be any time at all that you and your husband and a staff person or another agent ever be there at the same time?
Oh, there's always an option
Do
for
you
that.
commute together to the office?
Sometimes we do, sometimes we don't.
There's a possibility there'd be 3 cars there.
If we sold that to a family that had 4 licensed drivers in the
We're
home,
not talking apples to apples here. That's
Yeah.
apples to oranges. If it's a house, it's a permitted use.
correct.
You're under a different set of standards
Okay,
when it comes to professional office.
correct.
I'm just saying that in reference to parking.
Yes. So in reference to parking, we did already have estimates come out, but what I was informed of is that if we apply for the special exception, that if it is granted, we cannot actually add more gravels or more paved area. So we could only pave what we already have graveled. So not only do we have a 1-car attached garage, you can actually fit 2 cars directly behind that. And then we do have 2-car capacity that fits behind the property, which is where I actually wanted it to be the handicap parking, because I actually wanted to have an 88 entrance at the back of the property.
Thank you.
You're welcome.
What's the square footage of the property?
1,550 square foot.
Now, is that not including the garage? That's just the,
That's not including the garage, and I would say 600 of that is a kitchen. It is a 3-bedroom, 2-bath, smaller home, which is why it did struggle selling. It was listed at $430,000. It was my listing. Biggest feedback that property had was that. So the option was the previous seller was going to rent it out potentially, like the previous people did for 10 years. We thought a much better use of that property would be to bring another business to Berkeley County. Per the zoning ordinance, it stated it was allowed.
okay, so you say it was 1,500? So roughly that's, per the ordinance, you need about 200 square feet per vehicle. So that was about 7 parking spaces, not including the employees. So you're talking 10 parking spots?
8 spots.
8 spots?
8 spots.
Are there going to be able to be 8 spots there?
That would depend on
Because I'm looking at the
once we are
setback too. The
allowed.
setback is another issue.
Can I say one thing? I'm just gonna speak to something really quickly. So for the record, I'm Laura Hoff, Master Planning Department. The property at 54 Showers Lane, per the Planning Commission, the stormwater ordinances, building code, they would not be required to have any type of parking because they would not be altering anything outside of the footprint of their home. So if they were going to add any type of impervious surface, which is anything that's not grass, so any sidewalk, any driveway, any addition to the existing building, they would need to come into compliance with the subdivision ordinances and the stormwater ordinances. But since they're not proposing anything, we, as in the planning department, wouldn't enforce those regulations that you're speaking to for the space per 200 square foot of area.
So they don't have to comply with that ordinance within the Tuscarora zoning ordinance?
They would comply with the Tuscarora zoning ordinance, but
That
there's no
would-
parking regulation.
Yes, there is.
is.
In section
For-
4, it says 1 space per 200 square feet for a professional office.
And it breaks it down into real
So
estate
again,
offices.
so we're talking about a site plan starting from scratch is what those requirements are. So you're talking from raw land to building. Those are what the requirements are of a new structure. But in terms of Berkeley County, a site plan can't be enforced upon a structure that isn't being altered in any way.
But the use is changing.
And so
Residential to commercial.
I can't speak to the permitting requirements, but Brian Ross could probably speak better to the requirements for a change of use permit.
Because the only thing we have right now to go on is what's in the ordinance. And that's,
And I
aside
agree.
from the setbacks, that
And I agree, it's just, this is a little different from other special exceptions that have happened previously, because we're talking about a structure that's not being proposed to be altered in any way. A lot of the special exceptions, started from raw land and were raw construction, went through the site plan process with the county as well as with the zoning ordinance. So those, those requirements for parking, they don't pertain to something that's not being altered.
So if I were to set up a home business in my own house that's 4,000 square feet, I would not have to provide reserved parking in
From-
addition to what I already have.
From a Berkeley County Planning Commission standpoint, no, you could operate that underneath, whatever business you wanted to run out of your home, you could do so. I think in this case, she's coming in and she's asking for the special exception for the use to be permitted for the home office, but we can't force somebody into a site plan if nothing's being proposed to change, which nothing has been proposed at this time to be changed. That's why you don't have any site plans in your packet. And it's different from the other special exceptions that I've seen that were, happened before my time. But Brian can talk to the requirements for the change of use permit.
For the record, my name is Brian Ross. I'm the Director of Community Development for Berkeley County. As for a change of use permit, in this case, anything interior that was done is all non-structural, so that wouldn't require any permit based off of the 2015 IRC or IBC codes, which West Virginia has adopted and Berkeley County has adopted. As for a change of use, she would be required the office space for it to be ADA compliant based off NFPA regulations, which would basically constitute handicap parking, ramping, basically hallway widths, any access to the office would technically have to be ADA compliant, or any restroom facilities accessed to any of her clientele in there would have to be ADA accessible.
So going back then to the parking, because of the ADA accessible aspect of it, well, how many handicap spots will there have to be?
There would technically only have to be one,
Okay.
is what it would
How many total
require.
will there be? I'm just curious.
What's that?
How many total parking spots will one?
Yeah, and unfortunately, I can't enforce any regulations as for parking spaces. That's why in the state of West Virginia, if you're in a residential development, a PUD or something like that, that's where your HOA covenants and restrictions supersede any sort of county or state regulations. And in some rare cases, there is minimal zoning in the county. Any other questions?
So just to confirm just one more time, so what we're looking at in the zoning, in these ordinance, like far as the setback, I understand you get it a staff report. You talk about setback, front yardage, footage, and things like that. The property does not comply with that. There's not the offset on the side nor the back. Now the front it is because it's a corner lot, but none of that really matters. You're saying because it's an existing structure, it's not a new one.
Correct.
Setbacks are determined at the time of lot creation. So when the lot was created, it would have been dictated setbacks based on its use, which obviously was residential. Unless a site plan was required, that's the only time that we could request the setbacks to be altered. But existing structures are grandfathered into that at that point. So I'm not sure what the residential setbacks are, but we wouldn't require them to be changed unless a site plan was required.
Correct.
Just, excuse me, just to revisit, are you saying, Laura, that section 610 does not pertain to this issue?
Section 610, which is, I guess, the section that pertains to the requesting of a special exception.
Let me read you one sentence.
I mean, I have it here.
Okay. And you could go 610, which is professional and business offices, A, B, and C. And if you're telling me it doesn't pertain to existing property, well then explain to me what the one sentence, the exterior of the premises shall not be changed or altered. Are you saying after someone would build on a brand new piece of land, now they're gonna come to us and say, we wanna change that and change the roof line or change a window, or that tells me that it does belong as part of existing structures.
I think this is pertaining to the alteration for signages, and it
That's
says
a whole
the
nother category.
The exterior of the premises shall not be changed or altered, nor shall any nameplate or other sign exceeding 2 square feet in the area be displayed on the premises. But before that, it says, such uses shall be located, constructed, and sound controlled as to protect tenants of the building from noise, odor, and office traffic. So that section for me, what I translate that into and what I was, this was something that we discussed internally. We discussed it with the legal department. We discussed it with county engineering, and of course with the planning department. When I read that, I read that as an alteration to an existing building, period. Intent, I can't think of what previous intent, like you're speaking to, if a building was constructed and then they automatically alter it.
Yeah.
I mean, I can't speak to that, but the way that I read this is, if a building is existing and it's altered, that's when we would require a site plan, and that's when we would require all of the items from the subdivision ordinance and also the ordinance, the Tuscarora Community Zoning Ordinance, those items. That's when we would look for those to be provided, but nothing's being proposed to change. So from a planning commission standpoint, because that's my stance, that's what the staff report's for, and that's the guidance that I'm giving you guys tonight, that I'm looking from a planning commission standpoint. The zoning ordinance, I don't enforce that, from a planning commission standpoint, especially since a site plan isn't required. So absolutely 610 pertains to this structure if it was proposed to be changed, but nothing has been proposed to be altered in any way.
So it would fall, it is a current building, right?
Mm-hmm.
But then therefore, C doesn't apply either? Or are we gonna pick and choose which does apply and not apply?
I didn't say that B applied. What I'm saying is I can't apply any of these items to force
I see what
a
you're saying.
site plan because
Yeah.
everything is existing and nothing's being proposed.
Well,
If
yeah.
they were proposing to expand the existing building or expand the parking, absolutely. Everything in its entirety would have to come into compliance, but since nothing is changing, the planning department cannot impose a site plan upon a resident.
Well, can I ask you one very direct question?
Of
then?
course,
Who can impose that?
a site plan. So site plans are required anytime there's a 5,000 square foot impervious coverage. So that's anything that's existing, whether that be cumulative with addition of impervious area or the land disturbance of an acre. So that's usually triggered by the stormwater district and the engineering department with land disturbances or building permits. Obviously, anything that's a brand new construction or a brand new commercial or residential subdivision with raw land, that comes through our department for site plan, but anything that's existing, so even if, say something outside of the zoning ordinance, say there's a building and the footprint is 4,000 square feet. If somebody comes in and wants a building permit for something that adds 500 more square feet of impervious coverage, even though we know that it's an existing commercial project, we can't ask them to come back to us with a new site plan. If they exceed that 5,000 square feet, whether from the jump or cumulatively over time, that's when we can say, whoa, you require stormwater management. It's really the trigger of stormwater management that requires site plans. It's not necessarily any type of activity, if that makes sense. Residential, commercial use, anything like that, it's the requirement of stormwater management.
Thank you.
When I look back, from the beginning, this property was constructed in 1944. And I think it's likely that that was a non-conforming lot whenever the 1975 Tuscarora zoning ordinance came into play, 1975. But because the property was already there, it was grandfathered in as a residential area, and the site as it was at that point. And that's the legislative intent that's written in the Tuscarora Community Zoning Ordinance in a couple of different places. So if it stayed a residence, there would be no problem. But because of the change in usage, then it comes under a new scope in terms of what is required for parking in that area, what's required for access. There's a state road right there next to it. 2 feet off the corner of the garage, actually, the setback is 2 feet off the corner of the garage. It's about 15 feet to the center of the street. There's a 30-foot right-of-way through there. And the state has the property, it has that road from Tuscarora Pike to Tuscarora Creek. So they need to continue to maintain that. And I know after going in and out of there for 30 years, there are many times when there have been cars parked, had to be in that right-of-way of the state road. So I think since the intent was by the people that wrote the Tuscarora zoning ordinance, that that's the way it was at that time. They can't change it, but they aren't going to foster that from that point forward. And it says it in here in many ways. It says a non-conforming use of a structure, a non-conforming use of land, or a non-conforming use of a structure and land shall not be extended or enlarged after passage of this ordinance by attachment on a building or premises of any signs intended to be seen from off premises, or by the addition of other uses of a nature which would be prohibited in the district, unless such extension or enlargement is authorized by the Board of Zoning Appeals as a special exception. And it says also, it is the intent of this ordinance to permit these nonconformities to continue until they are removed, but not to encourage their survival. Such uses are declared by the ordinance to be incompatible with permitted uses in the district. It is further the intent of this ordinance that nonconformities not be enlarged upon, expanded, nor be used as grounds for adding other structures or uses prohibited. So I think it's clear that the people that wrote these documents before us did not intend for that, intended that anything that took place up until that time was fine, but after that point, if there was a change in usage, then new requirements would be brought forth, and one of them would be parking and setbacks, of course, and parking lot setbacks. That's the way I read this. And you're saying that there's...
That just help. I mean, maybe I can help. Jeff Mosley, Deputy Legal Director for County Council. One thing to point out here is ultimately each of you as board members have to make your own decision as to what you think everything means in here. And this is I've battled with this document for a few days, just trying to figure out what I think certain parts of it mean. And I can't. There's no way that I can just tell you that there is one clear meaning. For example, what you were saying is correct. However, it also says that a special exception use is not a non-conforming use if it is granted. And the sentence you said was that it ends with, unless it is granted as a special exception. So you really have to decide things like all of these pieces here. For example, the parking. This talks about sufficient reserved parking for all these, patient or accommodate patients, clients, visitors. It's really a judgment call by the people on the Board of Zoning Appeals as whether that is sufficient parking, because there is a mention in there's that list in Article 4, but then this doesn't specifically reference and say sufficient parking pursuant to Article 4. So I think you could, if you choose to use that as a guide and say you believe that it has to have that many parking spaces to be sufficient, that's up to you to decide. We can't tell you one way or the other. That's basically, they're telling you what the county offices can enforce. What the zoning board can do is either vote to grant or deny a special use or special exception. So, and in doing so, the board will need to determine, if they deny it, what are the factors that are against it, or if they don't find any requirements under the ordinance to be insufficient, then they would normally grant that in a situation like that. But that's the problem with some of these interpretations is just that there's so many statements in here that, for example, it talks about site plan review required for all development and all uses requiring special exceptions. Then the next sentence says it's intended only for construction of buildings and other improvements on land. So does it apply to every special exception, or does it not if they don't require building something or developing the land in some way? It's a gray area, but ultimately, if you ultimately base your decision on those general requirements and special requirements that are in the section regarding special exceptions primarily, but there's also nothing in here that says you can't factor in your own judgment. I mean, it's a lot of these things are not definitely straightforward. It's for example, it says the location and size of the use, the nature and intensity of the operation involved in or conducted in connection with it, the size of the site in relation to it, and the location of the site with respect to streets giving access to it are such that it will be in harmony with the appropriate and orderly development of the district in which it is located. I mean, that's something that has to be decided by each individual member, whether it is in harmony with the appropriate and orderly development of the district. It's not in my opinion, it's not a clear-cut black and white kind of an issue. Now, with respect to some of the like the measurements of the lot sizes and so forth, again, it's up to you if you want to take those into consideration. I think there's nothing in here that says you can't. My instinct, based as a lawyer, would be because this building has been built before the ordinance was even in effect, and it was grandfathered in. Whether or not you want to consider that all of those requirements have to be met or not is a judgment call. It's not clear cut that that's the case. Whereas if this was a new construction, it would be very clear. It's just there are gray areas when it comes to the law, and especially depending on how well a document's written. This one, no offense to anybody who's involved in it, but it has some challenges in interpretation at different areas. But ultimately, it's just a decision as to whether you believe it meets. There are those general requirements and specific requirements that are, although I said the design regulations portion of the specific requirements in Article 6, there's an argument that those are not necessarily to be considered when looking at an existing structure because they're design regulations. If nothing is being changed, that's one thing. Now, as far as professional and business offices in 610, I think all of those things should be considered to the extent possible. But again, they're kind of gray in some of them. Now, the first one, it's a real estate agency. Obviously, you check that box, I would think.
Right.
The one about altering the outside of the premises or having a sign, basically, I would think that would be, if it was approved, it would include a requirement that they can't have a sign, any signage more than that size. Otherwise, it would require some special consideration of variance. The one about the parking, though, again, that's kind of a determination that you can use your best information, which you might say it's in here, you might think it's from the subdivision regulations, or if you have some other source of information, you might rely on that. But it's not explicitly stated right in that section what they mean by sufficient reserved parking, which it puts in quotation marks, which it doesn't put in, I don't believe, into that section, Article 4, where it's listed. So hopefully that was somewhat helpful. Does anybody have questions?
I have another question. So if, let's say, we grant the exception to do a real estate office with the way it is, with the parking the way it is, that exception carries forward forever for any other owner moving forward. Is that correct?
I would say yes.
Okay. So then if they decide to sell this office to another real estate agent that then has 4 agents and clients in and out all the time without altering the structure of the facility, then there would be no way to enforce that you need more parking to accommodate that extra.
Unless you make that an additional condition that the ordinance contemplates can be placed on, let me just glance at the language, that the board's authorized to add this to the specific requirements any additional conditions that it deems necessary, basically. So in violation of those conditions would be considered basically making the special exception no longer valid. So, I mean, it's within your authority, from my reading of that, for you to say there can only be X number of parking spaces, or it's for use as a real estate office with no more than an X number of employees, frankly. It's very broad, the language.
Or could we put it as it's only valid as a real estate agent as long as it's owned by, and that if she sells the property, then that special exception does not carry forward?
That's a good question.
I think it says in there somewhere I read where once the change is made, it continues that way.
I believe it does say that somewhere early in that ordinance, but generally that's how it would work.
Okay.
So when if you proposed putting language in there as an additional consideration or condition that generally goes against what other terms of the ordinance would be, it's probably not something that would stand out.
Okay.
This is an interesting question, Ed.
Something seems a little bit backward to me.
Okay.
If someone was to move in there and the change of usage, then our option is to say yes or no. But there's no option, though, to say or to have the application of the parking and setback and all these other criteria, because we wouldn't be able to do that prior to making a decision. I mean, shouldn't that information be given to us first, like this is what we want to do, this is what we're going to want to do with the parking spaces, and then we say yes or no to that, based on the regulations that are in the proposals.
And I mean, that's one of those things that you have to make a decision as to whether you're satisfied with the evidence presented by party making the application, that it would meet what you believe to be the requirements. You know, I mean, there is a provision that after, that if it's, if a petition or an application is denied, a new request or a new petition can't be made for 1 year. It means that it could be made after.
I had another question. I don't know if anyone in the planning department knows or not, but whenever the application of the property changes to, if it changes to commercial, would the state road have any criteria for how that entrance would come onto the road then at that point?
Yeah,
It's on a
That
corner.
would, yeah, so that would be for the homeowner to notify Department of Highways about the change of use. Department of Highways might say, you need to do X, Y, Z. Quite honestly, with it being existing, they might say it's fine and they can't do anything about it because it's existing. But I can't say what DOH would say, but that's not something that that we do. That would have to be handled by the owner.
I'd say something.
Yes.
I just wanted to make a comment to a question that you had asked in regards to, say we were to sell it and another real estate company buy this. Just keep in mind, this place is 1,550 square foot. That's only 3 bedrooms, and they were very, very small, like 9 by 9. So even the real estate franchise that I work with right now that has a total of, maybe 6 or 7 agents at a time, it's a 3,000 square foot office. There will be no other type of real estate company other than someone like myself who's opened a boutique shop, is what we call them, which is a small mom and pop. You can't bring in a big real estate company to such a small square foot area. It would not work. Most real estate offices are going to run from 2,500 to almost 8,000 square feet. So once, we decide at some point that we would need something bigger, then, we would buy something bigger versus, we're not asking to improve this. And then you still have the deed restrictions that followed with this property, which were actually from the zoning ordinance. So the deed restrictions on this property, even though this property was built back in 45, actually state as well that you have limited business use, and states that it can be a real estate office, medical facility, accountant office, things like that. So it's not like you're opening the door to then allow a car dealership on a half-acre lot on the corner. And again, the traffic that comes in from a small mom-and-pop real estate shop are no different than what a homeowner and 3-4 licensed drivers would be. So the impact is no different.
I think my biggest concern with the whole thing, aside from the setback and the parking, I drive back that road all the time, and I know I got to hug the right as I'm coming down Sowers Lane because you never know what's coming up on that side. The location of that property is right on that crest. And you can't see what's coming, you can't see what's going until you're there. Now, people who live back there understand the flow of traffic, and we kind of understand how to drive that road. But you've got people come in who typically don't as often come to your business. They might not take that into consideration. I'm just concerned, number one, come over that crest of the hill, somebody's trying to back out to leave. So that's another thing. But bringing up what we're talking about as far as the business, if you were to sell that, say you sell it to, we all invest in real estate for money. We want to make sure that we keep the value of our property. So you sell it to a doctor's office, a dentist's office. You talk about a lot more people coming in than you would in 1 or 2 in your real estate office. If we're opening that Pandora's box from a real estate company, we're opening it to, again, like I said, doctor's offices, dentist's office, whatever the case may be. You're talking about a lot more traffic. And so that's what concerns me. We can't tell what the future is going to be, but we have to, as a board, realize the possibilities of where we're going if we go from residential to commercial.
So a
that's
couple
one of my
things
concerns.
I'll remind you of, because I understand your concern. I'm a real estate agent, so I have to represent buyers and sellers, and I also have to be the voice of people's property rights, whether it's for myself now as being the owner, or whether it's a buyer or a seller that I'm here representing. We've got an accountant office 2 doors down and a chiropractor 1 door down from there, also Tuscarora zoning. We've got a doctor's office, or my dentist office, which is not too far down as well. Big facilities. We're talking a 1,500 square foot property. I don't think any other business would ever want to come in there unless it were someone like myself, which is why we have the seller here as well, who bought that property and then was selling it and took a huge financial loss on that because of the very old, outdated ordinance, no offense, that is very vague. It's limiting. The road structure is tough. For parking was not exactly the easiest as well. So that house has been there since before the ordinance came in. If it was really ever a concern when it was rented for 10 years with 4 drivers in there, how come no one ever did anything for? And we're the very, but there was still more traffic.
I think one of the big differences in your comparison is those locations, the bank, the chiropractor, the financial institution, your dentist office, has off-street parking, and a lot of it.
And at what point were any of those granted too? I've looked back and to see when there was a special exception put in, when they were able to add on to their parking lots. Not all of them actually have direct on and off from Tuscarora either. They are also off of side streets. My dentist itself, who I spoke with today, who they actually had 13 clientele in there as well as 7 of their own employees. 13, and that was half of the clientele due to COVID. On a normal day, there are almost 30 clientele in one day. So,
And they, at Chateau Gay, in that parking lot, at the entrance, where's the dentist?
the dentist is actually going to be Basins Drive, just a little down on the left. But again, this house is the very first house on the corner of Showers. So they're not coming up, they're not coming down. They pull to the very first property on the right. And Brian had something to say.
Just basically from a county perspective, you guys ultimately have to make this decision. If we were not involved in any sort of zoning, from a county perspective, the way we handle a change of use, just say, for instance, a lot of my tract builders in the county will build a residential house, turn it into a temporary real estate. Now, when you're considering about the parking, I'm not here to weigh your decision one way or the other. We base the square footage of the office space only for required parking. Now, I can't speak on their behalf or your behalf of what the actual office space consists of if parking is an issue. But the way we handle it is based off the square footage of the finished area of the office, which has to be ADA compliant and NFPA regulated. So I just wanted, I don't know if that helps or not.
Anybody else got to speak?
So I guess at this time, we'll open it up to public comments. So if anybody has comments they would like to add.
I'd like to thank everybody for taking time to come out tonight. Apologize, my health isn't very good this week. Everybody made very good points. I've enjoyed listening to your all's comments, and your all's. I'm going to kind of touch base from the factual side and from the personal side of living on Shires Lane for 30 years. A lot of these things I may be kind of duplicating a little bit because I make myself notes. As I understand it, based on the staff report, the county staff is recommending approval based on the property being in the growth area as shown on the comprehensive plan, which they stated, and it is compliant with subdivision ordinance. I didn't see in the staff report any of the materials that were submitted, so it's hard to tell what was or if what studies were done. And I apologize if it's there, I missed it. County staff is not only obligated to make sure that the use is permitted, but to make sure that the other requirements are met to make sure that the proposal doesn't adversely impact the surrounding residents or properties. You could make an argument that although the use is permitted by special exception because of its location and existing configuration, it does not meet the requirements. There is not sufficient buffering or separation from existing residential properties. And just because the use is permitted, it doesn't mean it meets the intent of the ordinance. Based on you all had mentioned Dr. I think it's Bertsinger now, Dr. Bertsinger and the financial place and the bank. They all have access from King Street. I don't believe in my heart that there's any way that the West Virginia DOH would give you all access off of King Street, nor do I believe you all want the expense of trying to put that in there. Off Showers Lane is just not a good thing. It's a narrow road. It's been narrow. I've been coming on that road since the 60s with friends and stuff, and it's just a narrow road. You're correct in per section 610 of the zoning ordinance that a real estate office would be permitted by special exception. And I point you to and would ask how those items are interpreted or met for surrounding residential properties. And I suggest in inquiring how this meets requirements of specific in Article 6, Section 601 and 602.2 is a table of minimum yard requirements. This would fall under other permitted or special exceptions uses where the requirements are as follows. The front yard depth, which would be 40 foot, which there's plenty of room there, but this is a corner lot, and it really complicates things as to where it's located and to what it does. The side yard, there should be a 25-foot easement there right away. There's not. There's just a couple feet from the garage. And the rear yard is 50 foot, and it might be close. 10 years ago, 12 years ago, whatever it was, the Mawks wanted to do something very similar. And they wanted to try to put 11 parking spots behind the house and between the house and Mr. Browning's house. And that wouldn't be fair to Mr. Browning, nor I don't think 11 parking spots would ever go in there. In my opinion, this is a non-conforming lot and does not meet side or rear minimum setback requirements, and I would like to see a plan showing how it meets this criteria. Also, did staff review this request against this criteria? Some other things which everyone has kind of brought up. The parking at this house, you can park one car on the patio, you can park one car in the garage, and you can park one car there kind of in front of the garage. But in all my years of going up there, whatever car's parked in front of the garage is always out in the road a little bit. And if a couple people park on the patio, one of the cars is always sitting out in the road. I'm surprised there hasn't been more fender benders than there are. We would need to know like how many additional parking space exits. Was there a traffic analysis completed? What are the anticipated vehicle trips, which you did mention that, and that was probably pretty close. What signage will be installed, and has any signage been reviewed or permitted? Per the existing zoning ordinance, specifically states the maximum size is 2 square feet. The beautiful sign that she put up before Christmas was 32 square feet. And I appreciate y'all taking it down. Now, from a personal point, the house that adjoins directly behind this house belongs to Mr. Browning, and I believe he's here this evening. He bought that land and he built that house somewhere 45, 50 years ago to live in a great residential neighborhood on Showers Lane, and he still lives there today. The next house is the Pearl's house, Jim and Barbara Pearl. I don't know how many of you remember this, but that house belonged to Mrs. Pearl's parents. That house sat about where the King Street Bridge is, and her parents jacked that house up, and they moved it up there on the Showers Lane with permission of Mr. Russepto, and so that they could live in a great residential neighborhood, but yet get out of the plane of Route 81 because of it coming through there. Mr. and Miss Pearl, when Mrs. Pearl's parents passed away, they moved back here because it was a great place to live. And, they're up in their 90s. So you figure Mrs. Pearl's basically lived in that house 90 years. Then the next house is the Frankenberries. And we're enjoying watching the 4th generation of Frankenberry kids. Carson Frankenberry is growing up in the house that his father and grandfather grew up in. And it was built by his great-grandfather in the 70s. Again, they bought a house on Showers Lane because of the zoning, because of the great neighbors, because of what we felt we were protected from having any business on our street. It just can't handle it. Most of us have lived on the lane for 25 plus years, and we bought here because of it being zoned residential, and we paid a premium for it. And I'll be honest, both of you all paid a tremendous premium to buy them houses, and I can't believe that you paid that much for it, because I own rental properties too. This happens every so many years. Someone buys a house and they want to change our way of life. And I beg you, you can go anywhere else in Berkeley County and put up a business, but please leave our residential zoned area alone. We don't want any businesses in there. We don't want the traffic, we don't want the headaches, and we don't want what's going to change if you all decide to sell in a couple of years and another business comes in. You know, I haven't, which a lot of you all covered about the narrowness of the street and the blind spot. You know, Miss Zimmerman, she was 90-some years old when she passed away, and there's still a sign up on the telephone pole that says, please beware of Jews' hidden driveway or whatever, to try to get people to slow down. Because I don't want somebody, you know, a family coming in to buy a house from you guys, and they pull out there and back out and somebody hits them. If more parking is added, we talked about, you'd have to do a stormwater management report, and we'll have to figure out a way to handle the runoff. I think the only place, there's an inlet down right around the corner of King Street and Showers Lane. Folks on the BZA, you know, I realize it's your all's decision in the end. I feel bad for you folks, but I'll be honest with you, we don't want a business on Showers Lane, and I pray to God that you will not allow this to happen. Thank you all for my time. I'm sorry I don't feel better.
Order or anything, or just kind of?
Good.
You're next.
If you can, real quick though, if you haven't already signed the paper, make sure that you sign the paper. If you're out of order on the paper, just put like a number that you've appeared that way when Sarah does the minutes. She knows who is speaking and from what address.
Sarah, I'm number 1 on the list. There's 2 of them. Good evening. My name is Nick Antonetti. I'm a resident of Berkeley County. I actually live on Showers Lane at the end. I'm the current president of Mill Point Citizens Association. We are the development on the end right past Tuscarora Creek, right after Mountain View Estates. My family and I moved here in August 2015. Prior to that, I was in Woodbridge, Virginia, where we had a huge HOA, 5,000 houses. It was kind of a nightmare. Moving here, we like this small town, but I would be remiss if I didn't come here and speak. It's not hard to see. When you guys turn on Showers Lane, that's a residential area. When the sign went up, we caught a lot of flack in Mill Point. We heard from a lot of folks. I think it's pretty easy when you turn up that road. That road doesn't even have lines on it. It's one of the last roads to get plowed. It's a nightmare when there's any type of weather on there. You had a car that's sticking out into the road, and it's almost impossible to pass. And you guys had mentioned driving down there. A lot of us drive down that road as it is. The reason I wanted to come tonight is, in May, June, you guys had another application before you. We got together with Mountain View, Chateau Gay, and Showers Lane Owners Group, and we signed a joint resolution that basically went on stating that we would be against any business coming into the area. We would be for any denying of any exemptions to the proposed zoning application exemptions that had come before. I just wanted to come here tonight to reiterate that. As Mill Point, we do oppose this exemption. We would ask that it is denied. We would like to bring up the fact that we do have that current standing unified resolution. I don't think it applies apples to apples in this one, but it does apply to the zoning as a whole. And I just want to kind of come on record as the Mill Point president to speak on behalf of that development. Just kind of go on record as our opposition to this. We would like to see this be denied so that we don't have that Pandora's box, as you mentioned, of just houses smattering up with businesses operating in them. We've denied 2 within Mill Point that tried to put one up. They just came to our covenants and we were like, no, this isn't happening. So I don't know that the Showers Lane area right there up that thing has one, but it's just not a business area. And I understand that you can see Dr. Bershinger's, you can see the bank, you can see the other ones, but there's a clear demarcation line where those businesses are, where the residential area starts. When you turn up Showers, you're not seeing businesses. You see them when you leave, and that's how it should stay. So I would ask you guys to deny the exemption. Thank you.
Good evening. My name is Amanda Fink. I'm originally the owner of the 54 Showers Lane home. Basically with this house, when I purchased it, the wall was falling down, it was run down inside and out, and this required a tremendous amount of energy, time, and money to make it what it is now. The improvements that were done with this home were huge, not just on the inside, but on the outside also. I have a real problem when I sell a home, not as a business, but as a residential property, when the deed specifically says that it can be subdivided, part of it can be made commercial. I never went that route, and the reason why is because a sign was put up on a yard a week after my home hit the market, which prevented anybody buying that place. And it prevented that for 7 months, and that cost me a ton of money. When I sold this home to Danya and her husband, it was sold as a residential home. That's it. The amount of money that was spent wasn't even close to what I put into that place. I think that this is kind of being blown out of proportion. I mean, we're talking about the Marks that basically rented this property for 10 years to a sex offender. We're not doing that. We're trying to establish a small at-home kind of business, very little traffic, not trying to change anything in particular. You know, I just don't understand. I will tell you that. On my end, basically, I took a loss on the property because I wanted out of there. Living on 81 for 7 months was not pleasant. You know, at the end of the day, you have the judgment to make and call the right decisions. And I don't think that Danya is asking for much. I mean, she's trying to open a small real estate firm in a beautiful home that's been remodeled completely, which adds to the neighborhood. It's not a distraction. Do you understand? So I think that, you know, at the end of the day, you have to do what you have to do. But understand that place is being used as a rental. The property tax on that place is $2,500 a year. To have someone living in there as a resident. So that home was used for over 10 years as a rental by the Marks. Run down. Didn't look good on any level, inside or out.
I'm sorry, you were going to say something else?
Oh, no, go ahead.
Okay. Just to kind of hit a key point where you talk
Yep.
about adding value.
Right.
I drove down that road every day seeing the value going in that house. It's beautiful. It's a lot better than it was before, I will tell you.
I worked really hard on that place,
You did.
making it
It's
everything that
beautiful.
needed to be.
And I thought to myself, wow, that adds value,
It did.
right? But I don't see it, the value being there if it's a business,
Okay,
in my
so
opinion. I think,
I didn't sell it as a business.
I understand that.
I sold
Right.
it as just a regular.
'Cause but I'm speaking as property owners. When you mention the word value, I see
Right.
it value as a residence because you remodeled the
I
whole
made
house.
it beautiful.
Right.
That's right.
But I don't, when I see it as a business, then I don't see that value anymore. I see it as a business.
What I see is someone trying to open up a home business. It's no different. If you're renting a property, it's a business. They were collecting rent monthly from this guy for 10 years. Everybody in that neighborhood knew this. I knew this when I moved in on the date of the purchase of that place because the state police showed up. What I will tell you is I have remodeled it inside and out. And frankly, the home is definitely worth a lot more than what I got for it. I took a loss for a reason. I needed to get out of there and get to another place where it was quiet. Living in that home didn't do any justice to it. It's on 81. I mean, all you hear is 81 all night long. At the end of the day, all she's asking for is a home business. It's relevant that you understand that because it's not like she's trying to bring a bunch of people in and change the neighborhood. It's a periodic thing where somebody may come to the office to sign paperwork. Most of that stuff is done electronically. So at the end of the day, like I said, I mean, I worked really hard to get that place what it is. It looks nothing like it did. I have photographs to prove it. The reality of this is it should be used for something better than it is. As far as I'm concerned, that place could have so much potential, and it wouldn't affect the neighborhood. I mean, I don't understand where we're going with this. It's not like we're bringing in a large operation. We're talking about a home business. Most people that are either disabled or don't work out of the house. I mean, it's no different than that. And it really needs to be looked at that way. I don't think that we're looking to sort of change the neighborhood or traffic that's coming in. I mean, it's going to be periodically someone will come to her office. You know, with the signage, as far as I'm concerned, you know, if it's an issue with the size of the sign, then you just make the change. You know, at the end of the day, as the property owner, you know, I sold the place as a resident. I didn't sell it as a business. If I had it done, then I would have asked for what I wanted initially. Any questions?
I'll just make a comment. I believe what you're saying about it being a small residential business.
Correct.
It's not a home business because they would not be living there. But the problem occurs maybe down the road. We have to take a long-term view in this. And we just mentioned a few minutes ago, suppose it's sold to a dentist or a doctor, which are both acceptable uses there.
Correct.
That means a lot of people going in and out.
So you could also, I'm sure, in your stipulation state that this place cannot be sold to somebody else, you know, until basically her office is either shut down. I mean, why can't you just stipulate that in the document?
That was my question. And,
Yeah.
And he said that we could not put that stipulation in.
I mean-
It would not hold water.
There's got to be a way around this where she can do what she wants to do without having all this drama. The reality of it is the Marks used this home as a rental for 10 years. That's a business. They're accepting money for a person staying there. That's a business. That's no different. And more importantly, not exactly acceptable. It's not like what they did anything for the neighborhood.
There are several other rentals in that area.
Okay? So,
Within Mountain Brook and I'm sure in Mill Point as well.
again, it's a
As rental
business though,
homes.
right? You would agree. It is a business if you're renting the property to somebody, right?
Well,
It's
we're not.
the property is not classified as a commercial use.
If you're accepting money, as far as I'm concerned, for a property for someone to live there, and it's an undesirable person, which technically this guy was, yeah, it's a business. They're making money off of that property. So on my end, technically, I want to be clear. I didn't sell the home as a business. I sold it as a home. The reality is the front and partial of this lot could be commercial if it was subdivided. I never subdivided it, you know, and there was a reason for that. You know, there was a sign that sat up because of other issues behind in the plat of land for the entire time that my house was on the market, which prevented any sale to happen. Anybody that saw that home walked away immediately. And I will tell you, it left a bad taste in my mouth. I'm not happy about that. I think it's unacceptable to leave a sign up and block someone from selling their home. You know, at the end of the day, what she's trying to do is not terrible. What was there prior? Yeah, that was terrible. That should have been questioned all the way down the road. You know, that's where I'm at. Any questions?
Not just because you brought it up. Talk about you could have subdivided that lot.
Sure.
If you do that, then we're bringing the planning in because that whole thing changes.
Right. well,
Stormwater, all that stuff. So nobody would do that anyway because of the expense. I don't think it would be worth it.
Okay, so initially.
But I just
when
want to try to compare apples to apples. And
So let me understand this. Okay, so when I bought this home, right, outside of like gutting it and remodeling it inside and out, the plan was to subdivide the front piece through Rick Pill. I had gone through him basically to go back through the deed and see exactly what was what. I didn't do that because the expense that I got into with this place was staggering. And essentially, I went right back to the place I was before my divorce, where all my equity was tied up in this property. You know, on my end, technically, the subdivision never was something I did because essentially when the house hit the market, there was a sign that was put up on the front yard like a week later. It stayed up. Even after the planning issues with the plat of land behind on Showers Lane was resolved. So it was pretty clear that the only thing I could do was sell that home as a home. At the end of the day, I mean, you have the authority to make this what it needs to be. It's a great house, and it's a great location. It doesn't have to be this complicated. And there's got to be ways around this where you can open up a home business, get acceptable parking, and everybody be all right with it. She's not trying to open up something horrible. We're talking about a small brokerage office. You know, the place basically, as far as I'm concerned, although people may not agree, is beautiful inside and out. You know, that was basically something I did for that neighborhood. And I didn't have to. I could have left it to be a dump like it was when I purchased it. And trust me, the wall was falling down. There were issues all over the place. Yes.
With due respect, what we're looking at here tonight is what the application will be going forward.
Okay.
We really can't do anything about the past, and we weren't involved with that at all.
Okay. So I'm just
I
making it
appreciate your
clear.
comments. I understand.
I'm just making it clear that this property has been thrown a ton of money. The reality of it is to improve that neighborhood immediately. You know, you go down that road, that's the first place you see. So I'm just trying to be clear that when it was sold as a home. The other part of this is she's trying to open up a small brokerage firm in the house. You have the authority to make that happen, or not, you know, but the reality of it is it was being used as a business prior. For 10 years, someone lived in that house and paid a ton of rent. So,
Yes, ma'am. Thank you.
Any other comments?
Good evening. My name is Steve Mathias. I live at 700 Showers Lane. Lived there since 1996, I believe. Before that, I lived downtown Martinsburg. Couldn't wait to get out of town. It was great. Turn off Tuscarora Pike, and I was in a real neighborhood. Didn't have to worry about commercial businesses or anything. Perfect place to live, close to town with kids. Aren't a lot of places like that close to town anymore that aren't in town. So I, like a lot of these other folks here tonight, agree with a lot of the comments that have been made. Please preserve our neighborhood. There aren't too many left. Once the horse is out of the barn, there's no going back. You start with one house, and it's another house. One house wants to do something, then they want to improve it. They want to do more with it. Down the road, somebody wants to do something in the house. Next thing you know, the total environment is destroyed. I'm not going to talk about the specifics and the requirements if you do agree to allow this special exception. That's for the planning department. But if you don't remember anything else I said tonight, remember what 703.1 in the ordinance says. The purpose of special exceptions is to achieve compatibility with existing and planned development. Beginning to the end of Showers Lane is residential. There is an improved lot on Showers Lane. It's not residential. And we want to keep it that way. And then the other point I'd like to make that I hope you'll remember is special exceptions are basically a matter of development policy. I don't think we need to get into the planning things and requirements of all that. It's a matter of development policy rather than an appeal based on administrative error, or maybe in this case, hardship in a particular case. I feel sorry for the petitioners. Spend a lot of money on a house. They can't use it for what they want to use it for. But unfortunately, that's why we have regulations. In subdivisions, we have declarations of covenants, restrictions. We have the Tuscarora area ordinance, and there's a reason for that. And there's places in Tuscarora that you can have commercial areas. But Showers Lane is not one of the places suitable for a commercial area. It's in the home business. It's a business, regardless of how it looks. I heard the word drama, a lot of drama here. Well, yeah, it's a lot of drama. I've lived there since '96. Some other people have lived there a lot longer than me. It's a big deal to us. And hopefully we're going to live there a lot longer. Traffic is worse and worse every year on Tuscarora Pike. It's a nightmare getting out in the morning, coming home. Probably needs to be another stoplight. We'll never get an entrance permit to this lot in the Department of Highways, so they're going to have to come off Showers Lane. How would you feel if you lived across the street on Showers Lane, somebody was doing this? first thing you're going to think about is your property values, the traffic, the people coming in and out. So I've asked you to put yourself in those shoes. And then just a couple of other comments I heard, deed restrictions. I checked the deeds this morning, all the way back to the Showers deed of 84 acres. There's no restrictions mentioned in any of those deeds. Whether you can do something or can't do something. So I'm not sure what the reference meant there, the deed restrictions, but I didn't see any in the deeds. In fact, I've got the current deed. Property was purchased in October from Amanda Fink. And there's no mention of any specific covenants, restrictions saying you can do this. I didn't say you can't do it either, but I'm just not sure what the reference to deed restrictions was, because there aren't any in this deed or the prior deeds. Property rights, I've heard that mentioned. I'm a property owner. Most of these folks are property owners. We all have rights. We're just asking you to protect ours too. Thank you.
Thank you.
Good evening. My name is James White. I own property in Mill Point. My family has lived in the Mill Point subdivision for 34 years. I'm also a commercial property owner in the city of Martinsburg and recently retired my business that I had in Martinsburg. I've been on both pages, both sides of the sheet, commercial and residential. My property, when I purchased it, required a lot of changes that I had to make to comply with ADA, comply with parking, and I understood that was something that I had to do. But that was something that I did way before I signed the paper to buy this piece of property. I had to understand what I was getting into. Living in Mill Point for 34 years, I've seen a lot, gone in and out of Showers Lane a lot of times. And my parents moved there originally. They bought the house that my wife and I currently live in. And they came here from Washington, D.C. They retired. My father's retired Metropolitan Police officer. They retired here, and one of their requirements was to move in a residential area that was secure. Okay, being from Washington, D.C., and I'm a native Washingtonian, which is sort of rare nowadays. I couldn't wait to get out, obviously. I spent the first 45 years of my life in Washington, D.C. So I moved up here with the idea of eventually moving into that house and continuing on my family there. The problem I see with residential and commercial is, and it is a simple comparison to me, it's a box. And once you take the lid off that box, you can't put it back on. And I believe that Showers Lane, the two developments that are back there, plus all the residences that are there down to the creek, they have investments. We all have investments in these properties. I've heard about people investing in their property, putting a lot of money into it. Let me tell you, I'd almost be embarrassed to tell you how much I've put into my house in the last 10 years. A lot of money. Property taxes, I wish I paid $2,000 or $2,300 a year in property taxes. But I agreed to take that on. But I agreed to do that because I knew my house and all of our other property owners here have an investment. We have our whole life, and my wife and I have our whole life involved in this house, invested in not only this house, but my commercial property. And I don't want to see it turned into a multi-use area that I came from in Washington, D.C. The zoning down there is out of control, completely out of control. Residential neighborhoods are getting destroyed every day. And I'm not a lawyer, thank God, because I'd have a migraine right now just listening to everything going on. But there's a lot of gray area here. And I think when you have that much gray area and that many things going on, we really need to step back and think, okay, look, what are we doing? Because once we take that lid off, we can't put it back on. And that's what happened. That's what's happened in the D.C. area, Northern Virginia, all these areas. They took the lid off. And with Showers Lane, That's already a challenging intersection. I mean, I come in and out of there 10 times a day. And even if it's in ideal weather, you've got the school buses coming the other side. It's not really an intersection, it's an offset. So you've got to hope that the people on the one side will yield to you. You've got turning lanes coming westbound to turn left. It's a nightmare. And Showers Lane is what it is. It's not commercial. You can put lipstick on a pig. And the residents, the businesses they're talking about, the banks, the investment area, they all have entrances that enter onto Tuscarora or King Street, whatever you want to call it. That's a whole different ballgame. We are a community. We are communities. We're a lot of people there that have a lot of money invested in their property. And in my opinion, that we start doing this, we take the lid off, there's going to be no end to it. And who's going to suffer? Everybody will suffer. Certainly the property owners in Mill Point and the other real estate area. All I'm asking the board is to consider what's going on, to consider where we're at now and where we could go. I just by listening to everyone here, I got an education. You have to be forward thinkers. You've got to look ahead. And the last time I checked, there's a lot of commercial property available for Berkeley County. Why don't we use it? Why are we taking a residential area and just turning it into a gray area that's going to, I will guarantee you that it will go downhill from here. I have seen it in my lifetime. I moved up here to get away from it, and I've seen it, and it can happen. I thank you for your time, and hope you guys can do the right thing. Thank you.
Thank you.
Hi, I'm Quentin Gaynor. I'm another real estate agent in the area. I'm also a full-time student, full-time working. In my time in the real estate, I've seen that there is very rare that people still want handwritten contracts. Most of it's done electronically. You're always out in the field, showing homes, meeting clients at their homes. So meeting clients at the office doesn't happen as often as it used to. Most of the time it's over email, electronically, however it is. But very rarely you'll have a person that prefers handwritten contracts. Now for me, it would be nice to, as a full-time student working, it's hard to find time to make your way back home and focus on both school, work, and also dealing with real estate. So for that, it would give me a personal touch, as well as Danya, for her to be able to focus, not at home. It's a workspace, and if a client has to come in there, very rarely will they have to. It would just give both myself and Danya and a self of comfort for a nice place to focus and work on whatever's going on in our lives. Is there any questions? Thank you.
Thank you. Any other comments? All right. Did you want to respond to any of the?
Why did they need an office there if they're not going to use it? They just said they don't use the office, so why do they need it?
Sir, can you please say?
Oh, I did.
Okay. Can you please say your name?
Wayne Palkovic. And my biggest thing is, it's not quite as bad since they added more gravel along there for the parking, but that intersection was horrible. Yesterday, with the ice, I was stopped at the intersection and the car was sliding down at me, and I just floored it to get out on Tuscarora so I didn't get hit. Luckily, I didn't get hit, but it's a terrible intersection. Where they come out from the school, where the school buses come, it's further west than Showers Lane, and they just continuously turn right in the mornings, and it's impossible to get out of there. And you know, and if you look at the Google Maps, it even shows cars parked in the road on a Google map. Look it up. They're not on their property. They're actually on the road. So that's all I wanted to say. Thank you.
So the reason, of course, was stated in regards to why we did want a real estate office, which was a place in town. Really, my garage is storage for signs. When I've got to run and go sign a listing, instead of driving 45 minutes home down Back Creek, I've got a place locally. Yes, there are plenty of other commercial properties for sale. I absolutely loved her home. And the zoning ordinance and the attorney and the planning and zoning all stated that this was allowed. The deed says it. The deed does actually reference covenants, restrictions, zoning ordinances that run with the land, which then refer back to the zoning ordinance, which was dated in 1975. It's a hub. It's a central stop. If I want a cup of coffee, instead of having to run to Starbucks or run all the way to Black Dog in Charlestown, I've got my stock supply there. I can use a restroom. I can change clothes if I fell in the mud. You know, why does anyone else want something locally? And instead of having to drive almost an hour, depending upon where you're showing, it's for the ease. Yes, I did buy this property. My hopes are to make it a real estate office. I would say that if for some reason you guys do not read through the lines here where it states that it is allowed and understand that, planning and zoning, a lot of things are on my side here, and you make a personal decision not to allow it. It really sounds like that maybe going forward in the future, you should look at revamping your zoning ordinance, and also the zoning ordinance, Mill Creek and the other subdivisions back there should actually consider purchasing that property and doing something about that road, because it sounds to me that this one property is not an issue. It's an ongoing issue that they have with traffic there, and that to be a forward thinker, maybe that should be looked at for the future if you guys do not allow myself to open a business there. I'm a big girl. You know, you say no, I'll tuck my tail in. If I can't file an appeal, which I believe that it said that I had the ability to do so, I can move on. But the community obviously seems to be in a very bad position with the narrow roadways, the dangers, the speeding there, that maybe all three communities should come together and do something about that. I did pay $305,000. You could honestly offer me at least what I paid and fix the roads. Thank you very much.
Yeah.
My name is Janet White. I live at 688 Showers Lane. So my question has to be is, so if you're going to make this a business office and they want to make it ADA compliant, the current structure is not necessarily ADA compliant, is my understanding based on the residents, but they would have to make changes to the outside access doors and or the front steps and so forth to make it ADA compliant. Is that not correct?
It not be the front steps, but yes, some changes.
So you would have to make that parking space in the back ADA compliant, which would require so much access on either side. I don't know if there would be enough room
It actually does
to meet ADA requirements and so forth, but then also then trying to get out of that parking space. But again, you're making changes to the structure to make it ADA compliant. That may then invoke one of these other parts of the ordinances. I'm just saying. My question is wouldn't that kind of trigger some of that stuff for consideration?
Yes.
Is that true? I mean, if you move it as is with no changes, then it's grandfathered in basically. But if you start making changes, when does that initiate a whole nother can of worms as far as ADA? I mean,
So, if the van accessibility ADA compliance is, reached with the existing driveway and the posting of the handicap sign, then that would meet any change of use permit requirement in terms of from a planning department standpoint. The only time that we would require a site plan is if any impervious area was added to the site. So if a parking lot was expanded to provide that ADA compliance parking space, then yes, we would ask for a site plan that would require stormwater management, anything that's required of the subdivision regulations, and then of course, anything that's required of the Tuscarora zoning ordinance for design.
Would that also include width of doors and changing them if necessary, or?
Yeah, it would just be a standard 36-inch door. Standard ingress and egress is what it would require. Hallway widths would be the same.
Would if it would be necessary to change the opening to the front door, let's say, or the back door. My question, I guess, is does that constitute a change in the structure of the building?
No, it's still part of the standard ingress and egress. You're not modifying the structure. It's still the standard entrance and exit of it.
Okay.
Whether you add, most standard entrance doors are 36 inches. If you get into an older structure, some of them run what's called a 2.8, very standard. You get into a 2.6. That's minor modifications and minor framing, and basically header and jack studs just to.
Okay.
Yeah, it doesn't really. It's a modification, but it's not. It's just considered an alteration to existing.
It's still considered like an interior renovation because it's not an expansion.
Okay. And we're not adding any impervious area to the existing structure.
If there was, you would see a site plan before you, and it would be going before the planning commission. And the recommendation would be based on the planning commission's approval of a site plan. And I did just look up the ADA compliance for a van compliance, because that's what would be required. So it's 11 feet wide. A normal parking stall is 8 feet wide, and then it's always at the normal 9-foot depth for a parking space. So
they allow that for the turn radius of a wheelchair.
yeah, so you're looking at an 11-foot wide parking spot, 9 feet for ADA compliance.
What is the distance there?
And again, we're not here for you to do their jobs. We're here for you to make sure that you understand all the facts and for you to make a decision. They're the ones who come and do the measurements, and they check and make sure that we're following the appropriate guidelines. I result to the Planning and Zoning Commission and our building permits for us to actually have licensed contractors to do the work and make sure things are in compliance. So this is giving us the opportunity to actually apply for the change of use, which then comes my list of what things are actually changed by a licensed contractor and inspected by our county government.
So what is that distance back there?
I don't recall. We measured it some time back when they came out. And again, they'll enforce that and check that information. I did not come with dimensions here for yourself.
So I guess that closes the public comment portion. So I guess at this point, we decide what documents to consider part of the record.
We need a motion to close.
Oh, sorry.
I'll make a motion to close public comment.
A second.
All in favor?
Aye.
Aye. All right. So now we decide what, I guess, comments, testimony.
Would all comments be part of the public record?
I'll just speak to this issue.
Okay.
There wasn't really much in terms of documentation. It was staff report and the application.
Sure.
I don't think there's anything else to be considered for much. That and documentary evidence, and then all comments are automatically considered evidence that can be considered.
Right.
But you would just you could have someone make a motion to admit those two documents into the record as evidence of the application, the special exception and the report from planning.
Can you speak up, please?
I'm sorry. If the board so chooses, they could make a motion to admit those two documents, the application for the special exception and the report from the planning department as evidence into the record of this hearing. All the comments are already considered to be in the record.
Okay.
Were there any other comments that came in online during the meeting? Do you know?
So at this point, as we have the option to make a decision now, or we can table it for no more than 30 days for a decision.
That's correct.
I mean, obviously everybody wanted a decision tonight. I don't know how the board feels. We had a lot of information thrown to us, and without making a knee-jerk reaction, I don't know.
Well, I mean, it's always possible for someone to make a motion to vote one way or the other, or motion to table it. I mean, the body can decide what they want to do, but somebody usually will make a motion to send it in some direction. It'll be voted for or against.
I motion to table and reconvene at a later date.
Okay.
I second that.
Well, someone else normally would second it.
I second it, or I would have asked.
Okay. All in favor?
Well, I have a question before.
Yeah.
What happens between then and now? What are we able to do in terms of communication and gathering more information?
Nothing really, because it has to take place in a public hearing.
Right.
Can't really shouldn't talk about this case between each other if you're outside. If this is tabled,
okay.
You shouldn't say anything. If you want to think about it more or look at the ordinance more or something like that, or that's fine. But in terms of finding something that would be a document that you would rely on as evidence, or getting comments from other people, or discussing it with each other, that would be contrary to the open governmental proceedings.
I think for me personally, I need to read through the ordinance more because there's a lot of nuances that were thrown out. And like you said, you've been wrestling it with the ordinance for days, trying to work through some of those gray areas. So I think I personally need some more time to.
There's a lot of emotions here on a personal
Yes.
level and a business level.
Yes.
And we just got here this evening and realized that this ordinance is it's a gray area, and it's open to our interpretation. And I don't think we would be doing anybody justice by making a decision an hour and a half. Well, it's a little over an hour into the meeting without having some more time to chew on it and read into it. And I agree with John. That's where I'm at.
I mean,
if I have to make a decision tonight, I think I have enough to make it, but I like to make.
I think it's within your discretion to do your thing.
Yeah.
And the only thing is that a decision has to be rendered within 30 days. Yes.
I've also read somewhere in there it said 15. In section 7, I believe it was.
That may have been with respect to a different. An appeal.
Was that the appeal? Okay.
Yeah.
Sorry, I've had plenty
That's
of
okay.
time.
I was pretty sure it was, and 30 days is actually something that comes down from the state code. It's not,
Okay.
I'm
Yeah, I just wanted
It
to
may be
make
in
sure
here,
we're
but
within
it's-
whatever
It is a
boundaries we need
It's
to
a
do.
requirement for all board of zoning or board of zoning appeals hearings, whether they're technically called an appeal or some proceeding under whatever zoning ordinance is in effect. The decision, a written decision must be issued within 30 days.
Okay.
There's a person missing tonight on the board. Will that person be able to vote?
I would think they would need to abstain because they weren't here to hear and consider the evidence at the time that it was entered into the record.
Even if they were watching online.
Yeah.
I
mean,
just wanted to get-
it's one of those things that maybe they'll change the rules someday for
Sure.
something like that now with technology and needing to have
Right.
people. I mean, if they were online and, were communicating and were considered part of the meeting, which has happened some in recent
Right.
years, that'd be a little bit different, but since they weren't here,
They weren't present for roll call.
yeah,
Right, okay.
for roll call. So
Okay.
we have that with planning commission
Right.
frequently, that people will be watching online, but they'll be on the phone or something so that they can say that they are at present.
Okay.
So that leaves 4 people to vote.
Yes, sir.
And what if there's a tie?
Well, actually, there's three votes, and the president would be the tiebreaker. So there wouldn't be a tie because there will actually be 3 votes, not 4. The president is
Usually the
tiebreaker.
president only
But we won't
votes.
need it because there's only 3 of us voting.
Exactly.
right?
It's usually the president only votes
That would be different.
in the event of a tie. He's the acting president today.
Right.
So it's physically impossible for them to be. Well, I guess actually that's not true. One person could abstain. I mean, so it is still possible.
So it requires to have how many votes in order to move forward? 3.
You have to have a quorum.
Yeah. Majority.
And the abstaining would still count as does that count as a vote?
No.
Okay. Yes, you would.
No, but then it would be. I mean, say if it was 1-to-1, then the president would vote. Or if there were only 2 votes, then the president could vote to establish proper.
And I do ask if you guys decide to table it for a later date, if you could decide upon a date that will be back in here. I think if it's 30 days from now, you're looking at February 18th being a Friday is the last day a decision could be heard. So just keep that in mind.
And, I mean, I think you would want to try to set the date right before we adjourn, so that
Right.
the members
We
of the
need
public
30
would
days,
know.
What kind of a meeting is necessary at that point, just to come here and vote?
Well, you have to vote, yes,
Mhm.
because even though
It
there's
would be like a general meeting.
the
not public hearing.
the official decision that is required by the code is in writing, there has to be a vote on the record in an open session.
Right, but there wouldn't be anything else to that meeting, just.
Not necessarily.
Well, you could always vote to open up the public hearing again if you so wished, but you've already closed it, so you would obviously have to have a vote to open it back up. But generally, it would just be, a motion and a vote.
Basically,
Could we have discussion at that other meeting
Mhm.
without opening public discussion, just
Amongst yourselves.
amongst ourselves? Yes. Okay. So that's probably what would happen. At open the meeting, we'd have a discussion amongst the 4 of us, and then vote.
If that's what you would wish.
Okay.
That's okay?
that would be okay. You can even have discussion after the motion is made with the full vote.
So you guys want to pick a date?
I'm sorry.
What are you
I'm
looking at?
sitting president, I'm the state director, I sit on a lot of boards.
That's how I would do it.
And being fairly new to the 4 of us who've just started on this board as of, 4 months ago?
I think it's the first decision since like 2012, so.
Right.
And there's no formal procedure for these hearings.
It's like baptism by fire.
Right.
Yeah.
Exactly.
Well, I'm out the week of the 17th, 11th. So, if you guys want, may say it's good to pick a date now. I mean, or I'm pretty much open except for them. I'll be in Seattle.
And it'll have to be tentative. We have to check and make sure that county council chambers isn't
Are
booked
available.
for another meeting already.
Right.
Generally, it's been safe with the dates that we've been picking with Tuesdays and Wednesdays. But we'll double check that tomorrow when everyone's back in
Okay.
and let everybody know. But if you could just pick something that we could go off of.
You could try to stick between the Tuesday and Wednesday. I know Thursday evenings is always booked in here.
Okay.
A lot of times Fridays and even sometimes Mondays. And we're gonna be starting to get into budget hearings and stuff like that. That's gonna carry on past regular time too. So right this window right now, Tuesday, Wednesday would be beneficial if you guys can work that out.
Okay.
You guys do it next week?
Yeah, what,
Yeah, I'm good for next week. Next 2 weeks, actually. And I just need some time to. So I don't need 2 and 3 weeks, but
Yeah.
more than an hour and a half.
so Jeff, what date is that?
Next Tuesday, the 25th.
25th, 26th,
I'm on call the 26th, so
25th, then.
the 25th would work better for me.
And what are any other dates? Just Pat, yeah, I think you're tied up in February, March, you said on Wednesday.
Wednesdays in February don't work too well.
How about Tuesday in February?
February 2nd. Is it back? I mean,
I was gonna, give them a couple of options.
I got things the 1st and the 2nd. You said you're out the week of the 7th,
yes.
so that would be the 15th.
That would be the next available.
Yeah, it's available.
What about 2/4? That Thursday?
That's a Friday. I'm good except for the week of 7th. If I can make everything work, else work.
I'm flexible.
I am too. Y'all pick a date.
Let's shoot for the 25th,
Yeah.
All right.
and then if that doesn't work, then,
We'll follow up with confirmation.
okay.
January.
So we'll plan on the next Tuesday, the 25th.
Okay.
And then if that doesn't work, we'll just, I guess, email and figure out a date.
Yeah, we'll just double check with county council admin and make sure that the approve's not booked, and then, we'll post another agenda, like we did with this one, and then it'll just have to do date and the new agenda.
Okay.
125 it is.
So we have a motion?
All right. So do we need a motion for that? To-
You could have just included it in your motion for tabling, so if you want to
Okay.
have another motion for the date, you can do so.
Well, they didn't vote.
Oh,
Okay.
okay, she's correct, so you can,
And
redo your motion before you vote, I guess.
motion to table it to the 25th, I guess.
Yes.
Well, I guess I can't make a motion.
A motion to table it to the 25th of January.
I second.
All in favor?
Aye.
All right. So next is staff updates and discussion. We're good?
Good.
All right. Then I guess we need a motion to adjourn.
Yeah.
Motion to adjourn?
I'll second.
All right.
We're done.
All in favor? Aye.
Ah.
Meeting is adjourned.